Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, and Nick and Bruno. This week's two episodes will touch on estate duty and offer to purchases and cancellation or early termination of leases. The first question is out to you, Bruno. Well, two things are obviously a guarantee when in life, and that's obviously death and tax. SARS, the taxman. With that being said, Bruno, can you please, we are going to touch on your deathbed costs, right? Estate duty, right? Obviously everybody knows at this stage that when you do pass away or die, there are certain expenses that you need to pay over, even though you're dead. Can you please just explain some of the basic costs of these, to whom do we pay these costs to, and why, and approximately how much, and what determines obviously how much we pay, and obviously the consequences of not paying some of these costs, or if there's a shortfall. Bruno?
So deathbed costs are the one thing that people don't actually have a good understanding over. And it's very, very important because your entire estate planning is based on the amount of money that you anticipate will flow to your children. Recent calculations over real life scenarios that we've dealt with have shown that with some investors, up to 33% or more of their estate can be paid in deathbed costs. Now, what are deathbed costs? This could be anything from estate duty to capital gains tax on any assets that you might have, executors' fees, any costs in the estate to move properties in and out of the estate. And these costs put together usually amount to a fortune, leaving your heirs with far less than what you anticipated that they were going to get. And the worst part is if the estate is not liquid, if it doesn't have money, it becomes even worse because then these assets have to be sold and they will never reach your heirs. Now, there's only a couple of ways to actually try and mitigate against this risk. The one way is to have enough insurance policies in place to make sure that when these costs arise, there's an insurance policy that is able to cover it. But now remember, some of these insurance policies are also taxable. So you need to make sure that the insurance policy is high enough to make sure to cover the tax that it itself will incur. So that is one way of doing it. Make sure that you plan this out properly. The other way of doing it is trying to move your assets out of your estate before you pass away and giving it to the people that you anticipate will inherit the assets. Problem with this is if you start giving them away, you're going to end up paying donations tax in any event, which is basically the same as paying the estate duty. So this too is not always the best idea. And then the last way, which works great, especially for investors that have quite a number of assets, is trusts. Getting these assets into a trust, and from this point onwards, only buying assets within the trust, so that when you pass away, the trust retains those assets and your beneficiaries can actually still utilize them or benefit from them without any taxes or deathbed costs being paid on them.
Absolutely. So thank you very much, Bruno. Obviously, this is a question that it's just going to always remain relevant going forward, estate duty and deathbed costs. Right, and Nick, we'll do then the last question with yourself, which is an early termination, and it's also an OTP on the property that's involved. It says here that Nick, a tenant ended their fixed term lease early and is liable for associated cancellation costs. The owner has been marketing the property now for rental, but also accepted an offer to purchase for sale of that same property, with the buyer wanting to take occupation upon registration. That is the buyer that signed on the OTP. It would be impractical, the writer says, to continue marketing for rental for only a 3-month registration period. However, the owner wants to claim rental loss due to early termination as well. Can the landlord claim this loss under these circumstances? Nick?
Perfect. So there's two elements to this. Let's just deal with them separately for clarity's sake. So in terms of the existing lease agreement, the tenant has terminated the existing lease agreement, okay, and they've said it's a fixed term lease agreement. So the tenant is entitled to do this in terms of Section 14 of the Consumer Protection Act. The fact that they have terminated it earlier in terms of Section 14 does entitle the landlord to a reasonable cancellation penalty. Now, we've dealt with reasonable cancellation penalties a lot around here. And part of what we've dealt with in the past is to say the legislation indicates that a reasonable cancellation penalty is applicable in circumstances, but does not go so far as to say what is reasonable in those circumstances. And what is reasonable is going to depend on the facts of the particular case. Okay, so how much time period is left over on the lease agreement? Okay, what the original term is that the parties entered into. All of these factors are going to play out for what is reasonable in the circumstances. So to come to the question, is a 3-month period a reasonable cancellation penalty in terms of a lease agreement? It might be. It just depends on the facts of the particular case. Okay, whether what your lease agreement looked like, what the property looks like, what the intended agreement between the parties was ultimately going to be if the lease agreement wasn't cancelled early. Okay, so 3 months might be something that can be claimed, but it really depends on the facts of the case, which we don't have in front of us in terms of this particular case. Then there's a second part to this question, which is the owners are also engaged in the sale of this particular property, and it's going to be sold in due course. The 3-month period that they've given is what they anticipate to be the registration period for the sale of this particular property, which is a pretty common period for transfer. And they're saying, you know, they've got some reservations about whether they should put in another tenant for only a 3-month period. Look, you can have a lease agreement for any period that you can agree with a tenant to. Okay, so a 3-month rental period in respect of a property can be done. There's nothing in law that doesn't allow you to do it, but it is quite a short period. You know, especially if you're looking at a residential property, for someone to move in for a period of 3 months and then move out is quite quick. Obviously, anyone who's moved before knows how tiresome and how burdensome moving into and out of a property is, and a 3-month period is a very quick time period to do that, but that doesn't make it impossible. So you can enter into a 3-month agreement. There are some risks associated with that. As all lease agreements, you want to make sure that that person is going to move out. But the person in the question is thinking quite practically. It is quite difficult, and it is a circumstance where I'd say you might want to have some reservations about moving someone in for such a short period if the property is going to sell in 3 months in any event. So I agree with their reservations. It just depends on what you want to do in the circumstances, and you can try claim the early cancellation penalty out of your previous tenant. As I say, that is a different question in the circumstances and entirely depends on reasonability of the cancellation in terms of the lease agreement that you had with the tenant previously. So these are really two separate questions that you need to engage with at the same time.
Yeah, absolutely. Yeah. So yeah, thank you very much there, Nick. That does bring us, ladies and gentlemen, to the end of our questions and answers for the week. And thank you very much, and we'll see you guys again next week.
Perfect. Thanks, guys.
Thanks so much. Thanks, guys.
Shoot.